All right, victory is sweet. We just won our trial here for Tempe court. We had a client who hired us for interfering with the judicial proceeding, which in this situation, it's a order of protection that he supposedly violated. And today the judge acquitted him, saying he did not violate this. The order of protection said that he was allowed to text his ex, only texting, due to their child in common. What they basically claimed his ex called the police on is that the texting that she received was through WhatsApp and the Messenger app. She also said that there were 2 missed phone calls. So we had to argue at trial today that number one, these text messages, even though they were through WhatsApp and even though they were through the Messenger app, still count as text messages. And the prosecutor argued that those are social media apps, which, welcome to 2025, those are not social media. You can't just post to the public and have social media profiles. They are unique one-on-one messaging. Nobody else could access those messages other than them two. So the judge easily was like, those are all text messages. We are not getting that too, minute on the law of what texting is. And this is clearly not voicemails or voice messages or videos that he's sending. And the texts were definitely about their daughter in common, their child in common, who is too young to have a phone. The 2 missed phone calls, which happened basically one day, not a day, and then the next day. So within about 3 days, there's 2 missed phone calls. The judge and our client got on the stand and testified that they were accidental phone calls, okay? That when they called, he immediately hung up and he did not in any way intend to make the phone call. And the prosecutor argued that it doesn't matter. The phone call was made, period. It counts as a violation. Now, we had to prove, and we were able to prove with cross-examination of the victim, of the ex, that she never answered the phone call. She claimed that she also never hit the end button, which is good news for us, and that there were no voicemails on this, which means when he went and testified that it was a complete accident, it was true. It made sense, because if he actually called on purpose, either A, she could have answered, B, it would have went to voicemail, or C, it would be forwarded or something, and it literally wasn't any of those situations. So we had the best argument and basically proof without proof that it was an accident, which is one of the hardest defenses there is, because how do you prove something accidentally happened other than testifying that it was an accident? And do they believe you? Does the judge believe you? And the judge basically said, look, these are for sure text messages, and those phone calls, he's like, I'm a human. I've made phone calls on accident. I hurry up and hang up and hope that it didn't ring on the other side. The judge also said there was more of a philosophical argument here of, is an attempted phone call actually considered a phone call? And my argument in support of that to the judge was saying, well, if I attempt to drive to somebody's house, but I get halfway there and turn around, did I actually complete the driving to their house? Did I actually make it to their house? Well, of course not. I turned around halfway. So did the phone call actually go through and make it there? Did it get received? Was there communication? Was there words that were exchanged? No, definitely not. And again, we could have had the argument that it wasn't even him who made the accidental phone call, but he had integrity and was honest and said, look, that's my phone number. I did not intend to make these calls. There was an accident. And this guy had a class 1 misdemeanor. This guy, the maximum the judge could have given him was 180 days of jail for this punishment. The minimum for this crime would have been no jail if the judge wanted to, but for sure 6 months worth of counseling and at least hundreds worth of fines and fees. So big range on this. Ultimately, extremely happy that the case got completely dismissed by the judge. And that's ultimately the best we could ask for. Client was very happy. We're very happy. And justice has been served today.